It's easier to beg for forgiveness than ask for permission. And that is Thomas Clair Binger's mantra. You see, there was this incident back, a year and a half ago at the CVS store in Chicago. Some guys were looting it, and Kyle Rittemhouse was overheard, and it's on recording, to say, "I wished I had my AR with me so I could take some pot shots at them." Now, of course, I think most normal people realize that's just tough talk. He wouldn't have done it. We all say these kind of things from time to time. But whatever the case, Thomas Clair Binger wanted that introduced into evidence, and Judge Bruce Schroeder said, no, it's an other act that is not even remotely similar to what's going on in Kenosha. He ruled on it. Now, Kyle Rittemhouse gets on the stand, makes a statement about protecting property with guns, and Thomas Clair Binger thinks, I could go ahead now and introduce that CVS video footage. Yeah, it might have been a good idea to ask the judge first. Fait accompli, that which has been done, or something like that. I've already done it. There's nothing you can do about it now. Well, Judge Bruce Schroeder disagrees. Now, we're going to hear what happened, but more interestingly, we have a couple of legal analysts that are going to weigh in. And I've been telling you, lawyers are not impressing me lately, and these two definitely don't. Hello out there. I'm trying to get through.
With his powerful brainwaves cradled in the warmth of reasoning, it's time for Johnnie Walker Dredd to straighten you out on a thing or two. Emanating all the way from exciting Las Vegas, Oklahoma, it's the Johnnie Walker Dredd Show.
Here we go.
I believe, based on the evidence that we
don't care what you believe. Did you get permission? No.
heard, and more specifically, exactly what the defendant said earlier about admitting pointing a gun at someone who was merely jumping or sitting on a car, that the door is open now to this testimony. And I continue to believe that his state of mind, his intent, his belief as to self-defense is the core of this case. That was the basis for my motion. You were strongly inclined against it. I understand that.
Okay, it may have been the basis for your motion, but it wasn't the basis for the denial. And that's something he's not understanding. He thinks that he has just strengthened his reasoning for having the other act's evidence introduced, but that's not the problem. The judge's reasons for denying it have not been addressed. And that's the reason why the judge is going to get furious.
But now we're in the middle of trial, and there's been a lot of evidence that's come in that I think makes this relevant. So I'm attempting to impeach the defendant on his beliefs. I believe I'm entitled to impeach the defendant on his beliefs and on his statements.
I'm going to interrupt you now because you're talking about his beliefs. I think that's what they call...
His statements too, Your Honor. Because he just said, can't use deadly force, can't threaten to use deadly force to protect property. So now I'm impeaching him on that.
Your Honor, the court has seen no reason to change its ruling. And just so this record is clear, in spite of the lengthy statement by Mr. Binger, before we started today, the court specifically stated in Mr. Binger's presence, there's been nothing to have me change any of my rulings. There have been numerous occasions during this trial where they've opened the door. The one time when they're going into Mr. Rosenbaum's prior, the reason he doesn't like guns, and I said something, I whispered in Mr. Krause's ear, it's because of the prior convictions. Please stop, and he did. He knows if you're going to go into something that's been excluded in a pretrial order, you better ask the court, you better get permission. This is ridiculous.
Yeah, it is ridiculous. Again, if you put in a motion to have other acts evidence introduced, you have your own reasons for doing so. And if the judge comes along and denies it because of reasons of his own, you have to find a way to convince the judge that that reasoning no longer applies. You can't just come in and say, well, my reasoning is now stronger because what's happened here in testimony doesn't work like that. The judge denied it for certain reasons, and those reasons still apply.
wasn't excluded, Your Honor.
You know why it was excluded in the first place? Because it was propensity evidence. That is exactly what 90404 is designed to prevent.
That's right. Propensity evidence. The fact that Kyle on the stand said something about protecting property doesn't make it not propensity evidence. It's still propensity evidence. And by the way, propensity evidence, in other words, you're trying to convict Kyle for what happened in Kenosha, and you're trying to convince the jury that he's guilty because he's the kind of kid who would do that based on something that happened weeks prior. That's propensity evidence. It's not allowed. And Binger understands this. This is like the first year of law study.
You're talking about his attitudes? His attitude is he wants to shoot people. Now, I've admitted that kind of evidence in other trials when it...
Just to make sure we understand, the judge is saying his attitude was that he wants to shoot people. What the judge is saying is that's what Binger is trying to make a claim of. That's not what the judge truly believes, obviously. But you're going to see some media outlets probably try to take the judge's words out of context.
It's been appropriate. I didn't admit it in this case because, to me, what I've heard in this trial, and by the way, Mr. Richards absolutely correctly points out that just hours ago, I said I had heard nothing in this trial to change any of my rulings. So why?
Testimony, Your Honor.
Pardon me?
That was before the defense
Don't
testimony.
get brazen with me. You knew very well. You know very well that an attorney can't go into these types of areas when the judge has already ruled without asking outside the presence of the jury to do so. So don't give me that. That's number one. Number two, this is propensity evidence. I said at the time that I made my ruling, and I'll repeat again now for you, I see no similarity between talking about wishing you had your AR gun, which you don't have, so that you could fire rounds at these thought to be shoplifters, and the incidents in these cases, which are not, there's nothing in your case that suggests the defendant was lying in wait to shoot at somebody or reflecting upon the shooting for a vast amount of time.
That would have made the similarity stronger between the CVS incident and the Kenosha shootings.
Every one of the incidents involves matters that involve seconds in time. So I commented at the time, I don't see the similarity, and I don't see the similarity now.
If anything, the argument against this is stronger, because Kyle went on the stand and said that he didn't believe that he should use a gun to protect property. Thomas Clair Binger now wants to bring up the CVS video footage to show that Kyle is the kind of person that actually would. That's classic propensity evidence.
If it's not similar, that's the whole rule. Those are all the exceptions to 90404. Check the authorities. Wigmore and evidence. Judge Weinstein. Colonel McCormick. It's the prior act has to bear the signature of the accused, or it has to be so similar as to suggest it's a common plan or something like that. You have an incident where he's making comments about some alleged shoplifters versus crimes that involve instantaneous actions, whether premeditated murder or whether self-defense. That's for the jury to decide. But I don't see the similarity. I said it couldn't come in, and it isn't coming in, no matter what you think. Number two, I have to be concerned that with what Mr. Richards has said about the progress of the trial.
Progress of the trial. That's code for you've been doing this a lot and you're starting to taint the jury.
And when you were I said you were over the line, close to or over the line on commenting on the defendant's pretrial silence, which is a well-known rule.
Yeah, that's about the most fundamental rule in the justice system. You have a right to remain silent, and the fact that you're using your Fifth Amendment right cannot be used against you.
I'm astonished that would have been an issue. So I don't want to have another issue as long as this case continues. Is that clear?
It is.
Thank
But he will.
you. Ask the jury to come back in, please.
Oh, he hates Binger. This goes back a while. Go watch my video on the Guy Smith trial where Thomas Clair Binger tried to have a truck driver thrown in jail because he had a gun in his cab of his semi.
Riva, what's your reaction? Was the prosecutor out of line?
Okay, so now we're going to bring in a couple of brilliant legal scholars here. We have the one on the right. Who is it? Civil rights attorney. What did I tell you the last time I had a video on these lawyers? They don't bring in self-defense lawyers. They bring in civil rights lawyers almost every time because they know they're going to get a nice little leftist bent out of their opinions. The one on the left is a legal analyst, and I hope to God she's not a lawyer because she should not be in any courtroom.
Yeah, I think he was pushing the envelope, Anna, and judges, and this judge, we know this judge has been very active. He's been outspoken. He's called me out. He's called Jeffrey Toobin out. So not surprised to hear that he's calling this lawyer out. And he is angry. And lawyers know demeanor matters. Your relationship with the judge matters. All of that is being watched by the jurors. And jurors are listening to the facts. They're listening to the evidence, but they are also sizing up the lawyers. So prosecutors and defense attorneys have to be very careful. You've got to be zealous in your advocacy for your case, but you cannot disrespect a court's ruling. And this was a really important ruling that the judge made about an alleged prior statement that Kyle made about wanting to have his gun to shoot at shoplifters. Obviously, the prosecution wants to get that statement in because they want the jurors to think that he went there with the intent to shoot and kill people and that he has a propensity to shoot and kill. And the judge says, no, there are no similarities. There's not evidence in the prosecution's case that he was planning to shoot anyone or that, he, as the judge said, laying in wait. So he ruled that that kind of testimony, that kind of evidence couldn't come in. And the prosecution, stepped over what the judge saw was the line. And he was called to task. And jurors know when they're rushed out of the courtroom and they could see the expression on the judge's face, they see what's going on, they know something good didn't happen. And in this case, the prosecution was really taken to task.
Okay, let's take a look at Areva Martin. Areva Martin is one of the most sought-after autism experts in the nation. Yeah, this is the kind of person you want to bring in to give expert testimony on a murder trial. From humble beginnings in America's heartland, Areva's passionate advocacy on behalf of those whose voices are marginalized propelled her to the top of her field, graduating with honors from the University of Chicago and Harvard Law School. Fine. Relocating to Los Angeles, she founded a thriving legal practice specializing in ADA, employment, and housing disability discrimination, family law, and school law, bullying and harassment, among others. This is the person that they think, oh, perfect. We need somebody who really understands criminal law, especially when it comes to self-defense and murder. I know. Let's get somebody who specializes in housing disability discrimination. At least her opinions were fairly reasonable. She could have came down much harder on Binger than she did, but keep in mind, they brought not only somebody who is a civil rights attorney, they brought somebody in who got tongue lashed by Judge Bruce Schroeder. They were called out by Judge Bruce Schroeder because they didn't understand Wisconsin law. And so you understand why they brought her in. She already has a bad history with Schroeder. She is a civil rights lawyer. She's going to give a very pro-Binger kind of opinion. Actually, it wasn't that bad, but still. Now, the one in the middle is an idiot. Let's go ahead and listen to her. She's going to do everything she can to convict Kyle Rittemhouse right here. Listen.
But I wonder if the prosecution was out of line in the fact that, Rittenhouse told jurors he didn't come to Kenosha looking for trouble the night.
I just wonder if the prosecutor was really out of line. Are you kidding me? Do you have any understanding of propensity evidence and other acts evidence? Did you research any of this?
Of these protests, he says he wanted to provide first aid, and he laid out his experience as a lifeguard and that sort of thing. But
notice how she just dismisses it. Yeah, he claims to be an EMT, but we all know he came here to murder. That's what she's essentially saying.
The prosecution was trying to emphasize, Laura, that he brought an AR-style weapon. If he was just coming to save lives, this is a weapon he was too young to even be carrying. How effective was the prosecution on kind of leaning into that point?
How effective was he? Oh, I don't know. They had to call the jury out. The judge practically shot him right there if he could have. Yeah, very effective. But keep in mind, listen to her argument. It doesn't even broach the issue that Thomas Clair Binger and Judge Bruce Schroeder were grappling over. That was other acts evidence of propensity evidence. And she's basically arguing, well, he brought that big scary gun in. Can't we convict him of murder? Okay, so she's an idiot. The one on the left is just going to leave you dumbfounded. Listen.
They were good. I mean, every prosecutor has taken their share of tongue lashings when it comes to a judge, because judges always believe that they are in control of the courtroom. But
oh, yeah, it was really good. I mean, we get tongue lashed all the time. Well, you shouldn't be doing this. I thought that the whole purpose of a trial was to convict guilty people. And I've told people many times that it's no longer that. It's persecute. It's convict. It doesn't matter if they're innocent. So when you pull these little tricks, like bringing in propensity evidence in there, and you can get away with it, you think you've scored something positive for society. No, you've just inched one bit closer to convicting a person who could be innocent. We introduce these rules for a reason. And the reason why we do it for the acts evidence and the propensity evidence is we want people to be tried and convicted on the evidence of the event, not because of something they did earlier.
It's the prosecution's burden and therefore the prosecution's trial. And you heard him multiple times saying, I'd like to establish my record, explain why the door was opened. And that phrase is what Ariva is speaking about. The idea of even if the court should rule on a particular motion to suggest, I don't want the jury to hear things that are outside of the courtroom or things that you hope will get them to establish that this person once a criminal, always a criminal, or this person had already the intent formed, completely unrelated to the idea of providing medical care, to come with the intent to shoot people if property was damaged. The prosecutor thought that the door was open by virtue of Kyle Rittenhouse's own testimony.
I hope the prosecutors you hang out with are a little smarter than Thomas Clair Binger, because that was completely untoward of what he did.
So if the judge had ruled previously they couldn't bring it in unprovoked, if he opened the door, they are now entitled to do so, and he is making that record. And on that point, this is why it's so dangerous sometimes for defendants to take the stand.
Okay, so now she's going to blame Kyle Rittenhouse. And by the way, she's right. Maybe something that Kyle said did open the door. It didn't, but suppose it did. That's why you get permission from the judge to proceed. As Mark Richards said, that's how we do things. But again, Thomas Clair Binger fully believes in fait accompli. I'll just get the statement out in front of the jury and then apologize later.
No matter how rehearsed or smart they think they are.
Oh, Kyle Rittenhouse, he thinks he's so smart and he rehearsed so much.
If they are not well versed in the methodology of litigation, of trial procedure, and evidentiary rules, they may fall victim to their own hubris.
Yeah, Kyle Rittenhouse is full of hubris.
In this case, if Kyle Rittenhouse opened the door that exposes the Achilles heel of what his motivation was for being there and whether he had formed some intent prior to those interactions to kill anybody who harmed property, which he admitted time and time again prior to that tongue lashing, that you're not entitled in Wisconsin under these circumstances to use deadly force to protect property. Right. The prosecutor is entitled to go through that door.
No, he's not. He's not entitled to go through that door if the other act's evidence has been excluded because it's propensity evidence. You're supposed to be a legal analyst, and I'm not a lawyer at all. I'm relatively new to this, and even I know that. But keep in mind what she's also saying. What's Kyle Rittenhouse's Achilles heel? The Achilles heel is that he really did want to come to Kenosha to kill people. And this testimony he's given has exposed it. And all Thomas Clair Binger is doing is just trying to explore that. You see what I'm saying? She's claiming that that's his Achilles heel. And this is the reason why you have to be very careful with these legal analysts and legal experts that they bring on these stupid television shows.
But the record is made on the hopes of this being a conviction if you're the prosecution and trying to preserve it on appeal.
Well, once again, we see what they do. They have this little law show and they bring on their experts. And who are their experts? They're always going to be from the left. Civil rights lawyers are almost always going to be very dependable. And of course, they had this legal analyst, and she's out hanging out on the hard left. And she has Kyle Rittenhouse convicted. She's admitted it. He came here to Kenosha to kill people. That's his Achilles heel. And you can't fault Thomas Clair Binger for trying to expose that. Thomas Clair Binger is just trying to protect our community. At any rate, yeah. And they ask, why don't people trust the media? This is why. Like my video, subscribe to my channel.